The second issue concerns the French law, aimed at strengthening the so-called fight against sectarian aberrations. It is difficult to explain this term, since a new criminal article has been introduced. This situation is not unique to France, because similar laws or laws for the same purpose have been repeatedly proposed in Parliament, under pressure from lobbying groups in Italy as well, and with varying success in all the countries of the Union. France is not an exception when it comes to legislative initiatives that, under the pretext of protecting the state, affect society. The European Federation for Freedom of Belief, FOB, has addressed this issue in the past and continues to engage in extensive discussions on it since April of this year. Intravigne, Duval, Causaleri, and others are involved in this. It is clear that two articles of this bill infringe on freedom and are unacceptable, Article 2.3 and Article 12. The first one is an attempt to define the criminal offense of psychological impact, while the second concerns the crime associated with the refusal of medical treatment due to that same psychological impact. The adoption of both articles and the law as a whole is justified by the supposed need to eliminate a legal loophole and protect citizens' right to self-determination. But what exactly is the psychological influence that French law recognizes as a crime? Since Vance Packard published his book, The Hidden Persuaders, in 1957, psychological impact can no longer be considered solely as an individual's crime. Today, there is a wealth of literature on this topic. There are manipulation techniques, from advertising to marketing, from various sales strategies to politics and beyond. They have become a fundamental element of modern social structure. And in some countries, it is even regulated. If this is true, then psychological impact, as a crime under French law, targets the manipulator rather than addressing the problem of manipulation itself. This applies to sects, ideologies of minorities, in particular religious denominations that are different from the dominant ones. In particular, but not entirely, because even the dominant religious groups need to be cautious. From a legal perspective, Article 2.3 of the French penal law violates the principle of certainty and clarity of the legal norm. Paradoxically, the law entrusts the judge with the task not to verify the facts on the basis of the evidence collected, but to create the fact of a crime during the trial without taking into account the investigation preceding the trial. Thus, the judicial process, which is supposed to establish the fact